Two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years?
What begins as a routine court moment quickly shifts into a tense clash over control and legal understanding as a defendant stands before the court facing serious accusations that include resisting and obstructing officers, with possible punishment that could reach up to 3 years in prison. And the judge follows standard procedure by attempting to confirm a critical legal point, which is whether the defendant truly understands the nature of the charges and the risks that come with choosing to represent himself. Because before any person can give up the right to legal counsel, the court must be certain that decision is made with full awareness and clear judgment. Yet instead of giving direct answers, the defendant repeatedly shifts the discussion by challenging the authority of the court, questioning the validity of statutory law, and refusing to address the simple questions being asked, which creates a serious issue, since a courtroom operates under established rules that cannot be changed in the middle of a hearing. And while the judge works carefully through each required legal step, the defendant attempts to undermine the very structure of that process, turning what should be a straightforward proceeding into a struggle over who holds control, whether it is the court or the individual on trial. And as the tension builds, the situation moves beyond the original charges and becomes a clear test of authority, where the breakdown of balance leads to swift and serious consequences that no one in the room can ignore.
Hey, what's going on over there? What are you doing, sir?
I'm trying to make sure that this is going live. It's not happening.
Sit down. Sit down. You're disrupting my courtroom. Any more disruptions, I'm going to ask you to leave.
Is that a statutory jurisdiction? What is it?
Yeah. It's a statute. So that's my jurisdiction.
Well, I have another question because the statutory jurisdiction doesn't exist.
I've told you what my jurisdiction is.
One second.
Let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. All right, good afternoon. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access to our docket this afternoon, both in the courtroom and also online. Our first case this afternoon is People of the State of Michigan versus Trevor McLeod. It's filed 23-6748FH. Counsel, you want to state your appearance, please?
Anthony Julian on behalf of the people.
Okay, Mr. McLeod, are you present, sir?
Yeah.
You want to come on up to the table here?
I want to reserve all my rights.
That's fine, and I'll. Okay. All right. So, Mr. McLeod, this is the time and date scheduled for what's called for a circuit court arraignment. The case having been bound over to this court by the district court. So, you're here representing yourself today. Is that correct?
Yeah.
What's that?
Yep.
Okay. So I'm required by law to make sure that I've taken an initial waiver of your right to counsel in this court. So I covered a pretrial hearing in the district court. So we talked a little bit about this, but now it's up in my court. So you've got two constitutional rights. You can have you have the constitutional right to be represented by an attorney. And if you wanted to have an attorney at public expense and qualified, to have that. You also do have the right under our Constitution to represent yourself. Obviously, you can't do both things at the same time. So do you understand your right to a lawyer, including a court-appointed lawyer?
I understand that.
Okay. And do you wish to represent yourself instead of having an attorney?
Yeah, I'm here by special appearance, and I will be representing myself.
Okay. I'm required by law before I accept that waiver to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or a $100 to $500 fine. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
Okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No, so,
Hold on. I can't let you represent
Well,
yourself until I establish a couple things.
well, I need to establish a couple things too, honestly.
Hold on. Well, I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble.
Okay.
Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and/or a $1,000 fine?
I don't understand the nature and cause of the action against me, so I can
What
say
is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what
I
it
don't
is you don't
understand the
understand?
nature and cause of the action against me because there's no established jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine?
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction? So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General
The
jurisdiction.
people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power of Article 6 of the state constitution. The legislative power is exercised by the House of Representatives and the state Senate. They have passed statutes that the governor has signed. The prosecutor's office is alleging that you have violated those statutes. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So, Mr. McLeod, do you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and/or a $1,000 fine?
One second.
Hang on. Someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh,
Prosecutor's office is generally allowed to attend, to observe. They've participated. I'm removing them from the hearing. Mr. McLeod, do you understand the maximum penalty that you could face?
1 second. Okay, so in enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can we talk here?
I challenged subject matter jurisdiction. Nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter
doesn't
jurisdiction.
exist under the Constitution.
Your objection is noted. So, Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on. I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or a $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod,
the
stop.
court can be.
Stop, Mr. McLeod. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
I've challenged this court's jurisdiction. You haven't established it yet. You said you got a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr.
these
McLeod,
statutes.
I have other matters. Mr. McLeod,
Involved agency. What's that?
You know, I understand you want to object to things, and you're going to be allowed to object to things. Okay.
Sure.
But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt and you'll go back to a jail cell for a while.
No, Your Honor, I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
so before I can let you under,
I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying enough to where I can comprehend it, as you say.
You don't comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong, and you can appeal.
There's no such thing as a statutory jurisdiction.
Mr. McLeod, let me make this simple for you. Do you ever watch? Let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. You understand that?
So,
Mr. McLeod,
Mr.
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges. All right,
Mr. McLeod is in contempt of court, taken into custody.
Really? That's it. Protecting my rights is what you said last time. Sorry. This isn't true. You guys are
follow unconstitutional
You're following
orders.
unlawful orders. It's not constitutional at all.
Mr. McLeod's in contempt. He's sentenced to 1 day in Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is
notice.
unconstitutional. I did nothing wrong except to question and exercise my rights.
In a sudden shift, the situation reaches a clear breaking point as the judge takes action not to silence questions about authority, but to address a direct refusal to follow a lawful court order, which in legal practice is known as summary contempt, allowing the judge to respond immediately in order to preserve order and authority inside the courtroom. And what makes this moment stand out is the number of chances that were already given, as the judge asked clear questions, offered simple explanations, and issued direct warnings about the consequences of non-compliance. Yet the defendant chose not to engage with the process and instead continued returning to arguments that do not legally prevent the case from moving forward. And this highlights a key truth about how courts function, where individuals may challenge the system, but must still operate within its structure for proceedings to continue fairly and efficiently. And the short jail sentence that follows is not tied to the original charges, but is focused entirely on maintaining order and ensuring that the legal process is not disrupted, which turns this moment into a powerful example of how authority is enforced when limits are crossed. And it leaves observers reflecting on the balance between personal rights and legal responsibility, while also showing how quickly consequences can follow when that balance is ignored. And this case stands as a strong reminder that courtroom control is not optional, but essential for justice to move forward.